Article 188 of the Constitution confers power on this court, subject to the provisions of any act of the Parliament and any rules made by the Supreme Court, to review any judgment pronounced or any order made by it. Whereas Order 27, Rule 1 of the rules lays down that subject to the law and practice of the court may review its judgment, order of any civil proceedings on ground similar to those mentioned in Order 47, Rule 1 of CPC, and any criminal proceeding on the ground of an error apparent on the face of the record. It may be observed that Order 47, Rule 1 of CPC gives the right to a party to apply for review if he is aggrieved by the orders or decrees or decisions mentioned in subclauses A, B, C of Rule 1 on the three grounds, namely, of new and important matter or evidence which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed, or order made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason. Now, we may now refer to the judgments relied upon by the learned counsel for the parties. Mr. Sharifuddin Pirzada has referred to the following cases. Then they list 5 cases, but the most important is the first one, Lieutenant Colonel Nawabzada Muhammad Amir Khan versus Controller of State Duty, PLD 62, Supreme Court 335. And I read at the foot of this page, in the above first case, this is the 62 Supreme Court judgment, Cornelius CJ made the following observation as to the scope of review. Page 87, handwritten, page 87, my lord. The last about 5-6 lines from the foot of the page. In the above first case, Cornelius CJ made the following observation as to the scope of review. So this is referring to the 62 judgment, 62. PLD 62 Supreme Court.
For the present purpose.
G. For the present purpose, the emphasis should, in my opinion, be laid upon the consideration that for the doing of complete justice, the Supreme Court is vested with full power, and I can see no reason why the exercise of that full power should be applicable only in respect of a matter coming up before the Supreme Court in the form of a decision by a high court or some subordinate court. I can see no reason why that purpose in its full scope should not also be available for the purpose of reviewing a judgment delivered by the Supreme Court itself, provided that thereby found a necessity within the meaning of the expression complete justice to exercise that power. It must, of course, be borne in mind that by assumption, every judgment pronounced by the court is a considered and solemn decision on all points arising out of the case. And further, that every reason compels towards the grant of finality in favor of such judgments delivered by a court which sits at the apex of the judicial system. Again, the expression complete justice is clearly not to be understood in any abstract or academic sense. So much is clear provision in Article 163(3) that a written order is to be necessary for the purpose of carrying out the intention to dispense complete justice. There must be a substantial or material effect to be produced upon the result of the case if, in the interests of complete justice, the Supreme Court undertakes to exercise its extraordinary power of review of one of its own considered judgments. If there be found material irregularity and yet there be no substantial injury consequent thereon, the exercise of the power of review to alter the judgment would not necessarily be required. With a substantial or a material irregularity, the condition is there should be substantial injury because of that irregularity. The irregularity on its own will not lead to a review. The irregularity must be of such a nature as converts the process from being one in aid of justice to a process that brings about injustice. Where, however, there is found to be something directed by the judgment of which review is sought, which is in conflict with the Constitution or with the law of Pakistan, there it would be the duty of the court unhesitatingly to amend the error. It is a duty which is enjoined upon every judge of the court by the solemn oath which he takes when he enters upon his duties, which is to preserve, protect, and defend the Constitution and law of Pakistan. In the above report, Kekaus J, who rendered his separate opinion, made the following observations. To permit a review on the ground of incorrectness would amount to granting the court the jurisdiction to hear appeals against its own judgments, or perhaps a jurisdiction to one bench of the court to hear appeals against other benches. And that surely is not the scope of review jurisdiction. No mistake in a considered conclusion, whatever the extent of that mistake, can be a ground for the exercise of review jurisdiction. On a proper consideration, it will be found that the principles underlying the limitations mentioned in Order 47, Rule 1, CPC are implicit in the nature of review jurisdiction. While I would prefer not to accept those limitations as if they placed any technical obstruction in the exercise of the review jurisdiction of this court, I would accept that they embody the principles on which this court would act in the exercise of such jurisdiction. It is not because a conclusion is wrong, but because something obvious has been overlooked. Now, this is the other main ground for review. There should be injury caused and something was overlooked. Some important aspect of the matter has not been considered, that a review petition. Now, I pause here. This lays down, I would submit,
whether any exceptional circumstances has been clarified.
Yes, where,
what are the
yes,
otherwise exceptional circumstances kya hote hain?
where material injury has been caused, injustice has been caused, that is what the circumstances are. Somebody has to come and claim that I have been subjected to injustice because of this judgment and because of this error in this judgment. So error,
you mean to say
clearly all 13 of your lordships accepted this, is to create a parliament which is representative of the will of the people. That is the supreme value that our constitution embodies.
In this case, the review applications were allowed.
Yes, fine.
Reading the judgment.
That is fine. But the principles have been laid down. Because there was some law that was completely missed out on. They had not looked at some provision of the law at all.
Yes,
which is not
considered.
Not considered. Yeah. So yahan pe nahi hai.
An earlier judgment of the Supreme Court were also not considered while deciding
Yes,
the issue.
so that's fine. That is not the case here, I'll submit. There is no provision of the law that was not considered. So in one case, my lords will see, and my lady, a provision of the Tenancy Act was completely overlooked, and so on. 5B was overlooked in one of
Issue
these
of
cases.
reconstruction of building and the
5B,
reoccupation of the tenant.
Nobody had brought a specific section to the attention of the court. They said, look, the section was never before us. So that was the peculiar situation in which somebody was losing a very valuable right.
5B of the
5B,
Section 13 of the ordinance.
And because of that, one part.
next
In the second case that they've listed is Fida Hussain versus Secretary Kashmir Affairs, or they've looked at it and arrived at a conclusion, then that's fine. You may disagree with the conclusion, but they've not overlooked anything. And that if it would have been considered by the court, the final result of the case would have been otherwise. No review petition, however, would lie on the ground of a wrong decision by the court, or that another view is possible on reconsideration. So wrong decision is no ground to review a decision.
What are their grounds?
Their grounds are, my lord, फिर मैं अर्ज कर देता हूँ जिनका ग्राउंड क्या है
कि wrong decision है.
जी रिलीफ उनको दी गई जो कोर्ट के सामने नहीं थे. थर्ड पार्टीज हैव बीन ग्रांटेड रिलीफ. इनका ग्राउंड ये है कि आर्टिकल 225 की जो कंस्ट्रेंट्स हैं, those have somehow been ignored, have been overcome by the judgment. Some people had been declared successful as women and non-Muslim candidates on their behalf, the lists that they had filed, PMLN, People's Party, or before your lordships now. So those people had acquired a right to be treated as MNAs and MPAs, and they could not have been de-seated without quo warranto proceedings. So either proceedings in terms of Article 225 or quo warranto proceedings. So this is, in a nutshell, the expansion case, I would submit. This is the heart of the grounds on which review is being sought.
They are considering it is wrong judgment, or it is a clerical or typographical mistake in it. What is their ground?
They are saying
They are considering it as wrong. They are considering it as wrong judgment.
They are saying that they are saying that this judgment has been passed without quo warranto proceedings having been initiated. This judgment has resulted in